I'm Michael Feltman. Welcome to 3 Minute Insights. I'm an immigration attorney located in Dodge City, Kansas. This is episode 10. This is focusing on immigration court matters when it's an emergency. First thing is that a immigration court proceeding cannot begin unless an I862 form is filed with the immigration court. That's filed by Immigration and Customs Enforcement, which is ICE for short. Within the I862, or what we call the NTA for short, there's two major parts to that: factual allegations and a legal allegation. If you want to start representing someone in the immigration court, the form you have to file is an EOIR. Once the NTA is filed with the immigration court, there are two different dockets. What's a docket? It's basically a route. There's a detained and a non-detained. The detained dockets, depending on the immigration court, will have a court every 2 weeks to 2 months. If you're non-detained, in most immigration courts, you're going to have court about every year, sometimes even up to 2 years if it's a busy immigration court. If you are detained and immigration doesn't release you on what they call own recognizance or an OR bond, then you'll have to pay a bond. The minimum amount is $1,500. It has to be paid. Two important factors: if you do have an immigration bond or immigration detention, that is are you subject to mandatory detention under INA 236C? If you're not subject to that provision, then you're looking at maybe the bond being potentially too high. Then you can ask for something called a custody redetermination. Whether you're on the detained docket or the non-detained docket, there's two types of proceedings. The first one is what they call a master calendar hearing. Think preliminary court. That's where the NTA charges and allegations will be addressed. Forms of relief are addressed within that. Then the second is what they call an individual hearing. Sometimes it's called the merits hearing. That is where the form of relief that's trying to be sought is discussed, and basically think of that as a final trial. Final points with immigration court. First is that most people have the opportunity to try to fight their case with the immigration court. It doesn't automatically turn into a deportation the minute that they're picked up. There are some situations where that does happen. We'll cover that in future episodes. Second is that if ICE is detained somebody and they're asking questions about their history and their life, they're going to give them the option. Do you want to fight your case with the immigration court? Do you want to see a judge? Or do you just want to sign your papers and leave? Everybody's case is different, but generally I'll recommend folks to say, I want to see the immigration judge. Third final point with immigration court in an emergency, it can seem kind of scary. Remember though, God's in control, not anyone else ultimately. With that said, if you want to talk to an immigration attorney who's competent and understands the immigration court process, feel free to give me a call. If you're an attorney, feel free to call on as well. Thanks for listening to 3 Minute Insights. I'm Michael Feltman.